continue here with. Okay. Let's see. Okay, here we go. The next part, next malacha we're going to discuss is about partitions. Partitions are a suitable means of enclosure. Sorry about that. Partitions as a suitable means of enclosure are required in order to allow carrying inside an enclosed area, such as fences, hedges, or walls, and must be at least 10 tefachim high, 40 inches or 1 meter. If part of any side of the boundary is open or breached, one may still carry inside that area, provided that at least half of that side remains fenced, and the unfenced part is not wider than 10 amot, which is 4.8 meters. When suitable partitions have not been erected, an alternative method of surrounding an enclosed area may be prepared before Shabbos. One may form a tzuras, ha-pesach, literally the shape of an entrance, whereby 2 vertical posts are erected and joined on top by a horizontal post or cord. I don't know if you can see there's actually, that's it there. That's a cord, there's 2 posts there. So that's it. A number of conditions must be satisfied to ensure that a tzuras ha-pesach is valid. Examples of such conditions. The posts must be more than 10 tefachim in height. The horizontal cord must traverse or be joined to the top of the posts and not to the sides. The cord should be taut. There should be no intervening structures. And side posts must be used. Suspending a horizontal cord from the wall of one building to another is inadequate. So that's the picture again. That's obviously that's taut. You can see that's taut. I hope that. So
taut.
This one is wrong. This one is wrong because it's not taut. The cord is not taut. Those ones are. This one is correct because it's taut. It's tight.
So
there we go. So
it's got to resemble a wall in that it's taut.
Yeah.
It can't be like a washing on. So you taught us well.
I taught you. I was. Thanks, Damon. Please.
I took away your thunder.
I was going to say that. Yeah.
Sorry,
I was going to say no. I said it before. Okay, Gavin.
You taught us how to have a sense of humor after all these years. We didn't have it, and until you came along.
No, please don't.
And a sense of humor.
You have to. Don't lose it, please. Just be who you are.
Yeah, you do need a sense of humor.
And don't drink mainstay cane, because then you'll stay as you are for the rest of your life.
You know what? The sugar's got in that. I promise you, sugar kills me. If I had to drink mainstay cane, it won't stay as I am as the rest of my life. That'll be tickets.
I won't be, but I'll be under the bus for about a week as well.
Kevin, I never knew about that. It had to be taught with the Arif. I didn't know that. Thanks, mate. All right, so I'll tell you where we are. Our pace has been a little slow, but please God, it'll be better now.
Just 1 second. In Glen Hazel, they use the what's it called? Those electrical cables, which are not exactly taut, or is that taut? Maybe that's considered taut. Okay, just food for thought. Carry on, sir. Sorry.
No problem.
Are you sure about that?
Well, electrical cables are always a little bit flexible. Otherwise, they would.
No, you sure they use them for the Eruv?
Yeah, they do. But that's fine, Kevin. It's fine as long as it doesn't dip. There's always a bit of play, because what happens is there's expansion and contraction. So there will always be a bit of play. Now, same with your tiling. I don't know if you know that with tiling outside, with slaster tiling. That's why they crack or they lift. Because Jeff was explaining to me how you have to lay down tiles to take into account expansion and contraction of weather.
Yeah,
so
you're right.
It's never going to be taut, but it can dip. I think. Yeah.
Those guys that do the electrical work, I've seen it before. They pull it as tight as they really can. It's so hard, so they do pull it tight. It just loosens a bit. They make it slightly lax so they can have a little bit of flexibility for the wind and heat and all that type of stuff. All right, no, but it's obviously taut as far as it's concerned.
Yeah.
As far as Kevin's thing is concerned.
Yeah. All right, guys. So we're on 49A4. We really haven't covered too much ground this week.
Guys,
Yeah.
not only did I learn a lot, but you guys taught me well.
Cute. So, all right, we're on 49A4. So yesterday, what did we discuss? You were dealing with a Canaanite maidservant who had been recently emancipated. Well, at least even if she'd been emancipated for a while, she was recently married. How do we know she was recently married? Because if they had kids together with her husband, that was probably in a very similar station in life to her, a newly freed slave or whatever the case may be, or he'd even been, or it was a convert that married a convert, because people generally marry people of a similar life station and circumstance. They hadn't had other children, because if he had other children, then he'd have heirs. Then if anything had to happen to him, it would go to his heirs. So we talk about somebody that's recently married, and this is their first baby. Okay? So if the person intended to hit another fellow and this woman got in the way and she got hit and she lost the baby through a miscarriage, what happens there? Does the fact that, because we learned that the offspring always goes to the husband or his heirs. So what happens in that particular case? Does it automatically then exempt the damager from paying because there are no heirs? Why? Because as a maidservant, they then had to obviously, as far as I know, they had to become. Trying to think what happened there. They recently. How do I put it like this? They weren't their own property. Okay, they weren't their own property. As far as a convert is concerned, there's no legal heirs. Why are there no legal heirs? Because every Jew is connected to another Jew. What do I mean that every Jew is connected to another Jew? Is that you could make somebody an heir in your will because Jews are connected through Sarah and Abraham. So as far as that's concerned, that's why it uses that as an example. Okay. Now we're saying how do I put it? Okay, so like the Mishnah means that the husband died, he didn't have any heirs, the damage is exempt for the payment that is due to him, all the heirs, but not to the woman. So in other words, every Jew that's born has some sort of heir, even if it's not the children, they've got a brother or a sibling, because you relate. It's considered halachically that you related to your forefathers, Avram and Sarah. Okay? So the only possible cases in which a Jew can die without having heirs are those in which he is either an emancipated Canaanite slave who becomes a full Jew upon emancipation. I don't know if you know that, guys, because I never knew that.
Who does? A slave?
A Canaanite slave, yeah.
Doesn't have to do a conversion. Automatically gets status of a halachic Jew.
What's the meaning of emancipation? Just to get free?
Free.
Okay, so let me just ask, that's what I thought. So that's my understanding. So I want to ask just a quick thing, or to say something. I thought Canaanite slaves couldn't go free ever.
So apparently, Gentile slaves can't go free. I think there's some specific exemption with Canaanite slaves.
Is a Canaanite not a Gentile?
Well, I think it's a specific category of Gentile.
It's one of the nations. The nations that Jews are not allowed to marry. Or something,
I know what Gavin's referring to. We learned in Sota that the reason why, in many cases, I think they wouldn't be allowed to be free and there would be permanent servitude, was because we would worry that they would end up not keeping the mitzvahs after conversion. And therefore, just like we have somebody that we try and deter converters, because if they don't keep the mitzvah, they now affect the whole of Klal Yisrael. So it's better that somebody doesn't convert than falls off the wagon. So Gavin does have a point that I think there might have been a certain time where it was discouraged, or the emancipation was discouraged. But by default, immediately when a Canaanite slave was released, he had to go through a conversion. Gavin, I don't know enough about it. But just for the sake of this argument, if he becomes a full Jew upon emancipation, it's the same as a proselyte or convert. So in other words, whatever bond these people had with their non-Jewish families at birth is legally, it's halachically nullified when they become Jews. So they can have legal heirs only if they produce Jewish children after their conversion. So if they die childless, they have no heirs. And in that event, the law is that their property becomes hefker, it's ownless. And the first person to seize it acquires it. Does that make sense? So when we talk about seizing the money, if the money is in the damager's hands, he's technically seized it because it's in his hands. It's very difficult to extract money because possession is 9/10 of the law. So he's saying if the damager hasn't paid it, it's a difficult thing to extract from him. So that's when we say he seizes it because it's ownerless, means he doesn't have to pay it over because it's in his care anyway. So just to do a bit of a summary, there was a discussion difference between Rav Chisda and Rabba. Okay? So Rabba said very clearly that, well, actually Gavin and I see it from Rabba's point of view, so does Kevin and Arthur, is that Rabba basically said, well, let me just read the Mishnah statement. The Mishnah said, if she was a Canaanite maidservant who had been emancipated and had married an emancipated Canaanite slave, so they were newly converted Jews. So they obviously didn't have any blood relatives that were considered halachic Jewish. And if this was their first baby, then there were no heirs. Or if she was a convert to Judaism who had married a male convert. And in either case, the husband died without leaving any heirs, the damage is exempt from paying the value of the offspring. Now, Gavin said yesterday that that was unfair. I agree, because they both suffer a lot of pain emotionally, a huge amount of pain. But it was a different time. So obviously they worked it out in terms of, in a different way. So let's just try and see what the Gemara is saying. So we understood where Rabba was coming from. Because what did Rabba say? They taught us only concerning a case where the damager struck her during the lifetime of her husband. The convert being her and her husband, and then her husband died. So since he struck her and caused her to miscarry during the convert's lifetime, the convert acquired the debt of the value of the offspring. So what we're saying is, look, husband alive, wife is alive. Right? They're alive. Now, this is a legal case. So the damager, who's a Jew, damages the wife and she miscarries, and that money is meant to go to the husband's account. So it goes into the husband's account, his estate. Now, she had her account or her estate of what, and he had his account and his estate. So afterwards, unfortunately, if he died, she couldn't get access to it necessarily. In other words, what happens is a man had to leave a certain portion of it given to the children and a certain portion to his wife, according to what halacha dictates. So the money's already in his account, which means if he doesn't have any heirs, in that case, in that particular case, she doesn't get it. Does that make sense? Now,
he's obviously not, he's not considered an heir either.
Well, she's not considered an heir in this case, not in terms of the value of the offspring. I'll tell you why. It's because at the end of the day, it's seen as that he wants to carry on his surname or his name. So the benefit goes to that particular family name. Does that make sense? So if there's no heirs, there's no payment. So you could ask the question, well, if the money's already transferred, what do they transfer it back to the damager, etc.? So we say, no, he owes it. But what happened was he was alive at the time that the court said you owe the money. But then he died before the damager was going to pay it. Now he's off the hook because that account is closed. It doesn't go to the wife. It's different in a case where that account wasn't open, according to Rabba, and the husband's out of the picture because he died, and she's still pregnant, but the husband passed away, and then she miscarried because she was accidentally hit in the supermarket instead of somebody else. In that particular case, the money goes directly to her because it hadn't been legally transferred to the husband in terms of a promissory note. So Rav Chisda doesn't agree with this. He said, look, at the end of the day, are offspring bundles of money that she should be able to acquire them when the husband dies in the manner that one acquires ordinary ownerless property. What's he trying to say? Well, he's trying to say, look, offspring are not assets. You know what I mean? It's not like there's a property you're inheriting or something that that can be transferred to her. This was his hopes and dreams of having his surname continued or his legacy continued. When he died, that hope and dream died with him. It's not property that can be transferred. That's Rav Chisda's opinion. Does that make sense, guys? All right, let's go on. Rather, the law is as follows. If the husband is here when the offspring are killed, the merciful one awarded him the payment of their value. But if the husband is not here when the offspring are killed, the merciful one did not award the payment to anyone. That's Rav Chisda. So now Rabba's opinion is challenged. They challenged Rabba on the basis of the following brisa. If one struck a pregnant woman and her offspring were miscarried, he gives the payments of the damages and pain to the woman and the value of the offspring to the husband. If the husband is not alive, the damager gives the value of the offspring to the husband's heirs. Okay? That's fair enough. If the woman is not alive, what do we mean if the woman is not alive? If she died along with the baby. Okay, so in that particular case, you could have a law of Kim Lebedi Rabba Minay, meaning he gets the death penalty, and therefore there's no money owing. But let's say it's not about that. Let's say you're holding about like Rabbi Shimon, who said it's not directly intended for her. So therefore he doesn't get the death penalty. Does that make sense? So, or we say maybe she died of something else. Maybe she was so stressed at losing the baby, she wasn't watching where she was going and she got hit by a horse. I don't know. So in any event, so if she's not alive, he has to give the damages of what she suffered from the pain and the actual damages to her body that the damager caused to her heirs. It's possible that she could have heirs. Why? The husband could be a convert and she might not be. Or she might have had children from another marriage. You know, it's a difficult one to say. But the Gemara in 50, do you remember, guys, we did a Gemara in the 43rd daf explaining that it deals with a woman who had been divorced, so the inheritance goes to her family rather than her husband. So what are we talking about here? Do you remember when it says any damages for the offspring, where do they go? They go to the husband, even if he fathered the child. It doesn't have to be your husband. In other words, say she had sex with him in premarital sex and they weren't married, but halachically they could get married. Okay? So as far as the damages for the offspring is concerned, that would go to the husband or his heirs. As far as her pain is concerned, and her damages, she gets to keep it. Why? Because they weren't officially married, they were divorced. Maybe, in other words, we're saying that they were married at the time that she conceived, and afterwards they couldn't stand each other and got divorced, and then she obviously went to the bar to drown her sorrows and accidentally got clapped. So if the woman is not alive, he gives the damages due to her heirs. Otherwise, the woman's entitled to it if she's a divorcee. If the injured woman, so the damages and pain go to her, okay, if she's divorced. The offspring still goes to the father of the child. Does that make sense, guys? So, Kevin, it's as follows, right? The woman, the husband, or the one that fathered the child gets all the financial benefit of the offspring. If he's dead, it goes to the heirs. Okay? If they're divorced and she had a relationship with her husband before they got divorced, then still the offspring benefits go to him or his heirs, but any damages awarded to her in part, she gets in full, like damages for pain or damages to her body. There's no 2/3 and 1/3 sharing because they're divorced. Does that make sense? So if she's not alive, it goes to her heirs. All right. Now, if the injured woman was a Canaanite maidservant who had been emancipated and had married an emancipated Canaanite slave, so they're now both Jewish, or she was a convert to Judaism and she married a male convert, either case, guys, the husband died without leaving any heirs. The damages acquired the rights to the payment and is thus exempt. So neither left heirs. We see that even when one kills the offspring after the convert's death, he is exempt from paying for them, in contradiction to Rabba's opinion. Okay, so in other words, the Gemara assumes that when the Brisa states that the damages acquired the rights, it refers to both of the previous rulings. It means like the following, right? The husband dies, the damage acquires the rights to the payment for the offspring. What does that mean? He doesn't have to pay. And if the wife, who was also a convert, had no heirs, died, the damage acquires the rights to the payment for damages and pain, because he can't give it to her. So since the latter rule obviously applies whether the woman was struck during her husband's lifetime or after his death, it follows that the former rule also applies in all instances. So that contradicts Rabbah, because he basically stated that the damage is exempt from paying the value of the offspring only if he caused the miscarriage during the convert's lifetime and then died. Can you see the difference here between this Brisa and Rabbah's opinion? If you guys are not clear, ask me to clear it up. Kevin, this
go over it one more time.
Yeah, this Brisa is
I've been over it, but just go over it in one piece. I'll appreciate
this
it.
Brisa is contradicting Rabbah, because it's saying, look, if the husband dies, if the husband's already dead while she's pregnant, okay, the money doesn't all go to her for the offspring. It doesn't go to her at all if he doesn't have any heirs. Okay, husband died, no heirs because they're converts, or either because they Gerim, or they be both Canaanite emancipated slaves. Rabbah's saying, listen, if he died before she got injured, then she's entitled to that payment. If the husband was alive when she got injured, it should be promissoryly transferred to his account, and if he dies, well, then she can't get it back. The damager doesn't have to pay. And the Brisa is saying it's not true. Either way, whether the husband died before and after, it seems as though it's a contradiction to Rabbah. She doesn't get any of the money for the offspring. Does that make sense? So this seems a contradiction. So the challenge is rebuffed. They say, is this Brisa superior to our Mishnah, which similarly exempts the damager when the woman was the wife of a convert who died? And we interpret it as dealing with a case where he struck her during the convert's lifetime and the convert then died. Here in the Brisa too, we are dealing with a case where he struck her during the convert's lifetime and the convert then died. An alternative answer, I'll explain them both. Well, if you prefer to say the Brisa in fact deals with a case where he struck her after the convert's death, since that was the case, just hang on for me 1 second. We're back to a position where if he struck her after the convert's death, then he doesn't have to pay. So what are we saying here is that there's no real contradiction between the Brisa, okay, and the Mishnah. It's saying it's not superior, it's not a contradiction. Because what's happening is you're dealing with two different situations. Gavin, what two situations are you dealing with? You're dealing with the situation where she lost the baby, either while the husband was still alive, or he had died and she had the miscarriage after that point. So what we're saying is that this Bryce is not a contradiction to the Mishnah. If the husband was alive at the time where she miscarried, the damager doesn't have to pay because it would have gone to the husband and he was present in the world. Okay, so therefore, if he died, tough luck. She doesn't get his share. The damager can keep it. However, if he died prior to her miscarrying, she gets the entire amount because there's no heirs as he is a convert, same as she is. Very straightforward. So they're not in contradiction to each other. So that's rebuffed. So the Gemara now inquires whether the disagreement between Rabbah and Rav Chisda was debated previously. Why is it saying that? Shall we say that this is a matter of dispute between Tanaim? For it was taught in a brisa, if an Israelite woman was married to a convert and she became pregnant by him, and someone struck her during the convert's lifetime, causing her to miscarry, he gives the value of the offspring to the convert. Regarding a case where he struck her after the convert's death, it was taught in one brisa he's liable to pay. It was taught in another brisa he's exempt from paying. Is it not presumable that these brisot reflect a Tanaic dispute as to whether the convert's rights are acquired by the wife or not? Thus, the Tanaic opinions parallel those of Rabbah and Rav Chisda. So what it's basically saying is the Gemara doesn't mean to amend the brisa. It's basically saying that the first brisa means that the damager is liable to pay for the convert's wife because she acquired the right to that payment upon his death, and there's no one else who's liable. And then the second part of the brisa says it exempts the damager from paying. Okay. So what we're saying is it possible that this dispute that the Amoraim have are reflecting an earlier dispute between the Tanaim? Kevin, do you want to explain what it is, or should I repeat it one more time? Just the last bit.
Yeah.
Okay. If so, this is taught in a brisa by Tanaim. If an Israelite woman was married to a convert and she became pregnant by him, and someone struck her during the convert's lifetime, causing her to miscarry, okay? So he's alive, the husband. He's got no heirs. That's their first child. It gives the value of the offspring to the convert.
Yes.
And after the convert's death, it was taught in one brisa he's liable to pay. To whom? Obviously, if he had no heirs, it means to the wife or the widow. And it was taught in another brisa is exempt from paying. So you see here clearly that this is an argument between Rabbah, who said that, listen, if the husband is no longer alive, Kev, because there's a miscarriage, and he died before there was a miscarriage, Rabbah said she's owed the money. And Rav Chisda said, listen, this is not like property that's inherited. So therefore, she doesn't inherit the money. So it seems to mimic this Tanaic dispute. Okay. So the Gemara continues, according to Rabbah, it's certainly a matter of Tanaic dispute. But according to Rav Chisda, shall we be forced to say that it's a matter of Tanaic dispute, or can we perhaps explain both brisot as compatible with Rav Chisda's opinion? Okay.
Now, I've been over this. I think Gavin has also. Is the thing with is if let's say, because sometimes the language in the Schottenstein it's not so simple the way it's written, the way it's translated, and let's say a convert dies, there's no heirs. So that you think the and then the damager isn't exempt. So the money, he still has to pay that money somehow. He's not exempt from paying damages, but it doesn't say it explicitly. You see, that's the problem. You see, but if it sometimes it, I mean, I looked at it's written in a very difficult way. You know what I mean? It's not straightforward.
I agree with you.
And I went over it more than once, and it's maybe it's just a translation. It's not so simple to make it user friendly or easy. Maybe it's not so easy to translate.
Did you understand what Damon said before the link? Because he explained it very, very clearly. Were you concentrating the whole time?
Most of the time. I'm a bit tired, but
you really got well. I thought it was very clear.
Okay, so look, Kev, just the only thing of it is there's one opinion, Rabbi, that says there is payment to her only if he died prior to her having a miscarriage. If he's alive, the money gets transferred to his estate, and she's not entitled to that estate payment because it's not like it's almost a damages payment. It's not a payment for property where certain property can come from his estate back to her. But the problem is that obviously there was intent to pay. So if there was no payment made and there was intent to pay, the damager doesn't have to pay over because he gets to keep the money. But if the transfer was already done and then the husband dies, I'm not sure what happens. I don't know if he gets refunded the money, or in that particular case, it stays in his estate and she inherits his estate. I don't know. That is a good question.
It can't. How's it going to go back to that guy? You mean through the person who's sorting out the estate, what's it called, executor?
Well, I don't know if he's able to have a clash with the base den saying she's not entitled to it, because the problem is the minute it leaves his ownership, he's not the first to seize it. The estate has it. So the reality is, I don't know if he puts in a claim before the wife, if that's considered seizing it, or it's only considered seized because he hasn't yet paid it over. So the Gemara is just talking about a case where he's promising to pay it over. Maybe it's a big amount, and he's paying over every month. And then the husband suddenly croaks as a stroke of good luck to him and a stroke to the husband. And therefore, she doesn't get any of the money. He just doesn't have to make the balance of the payments, according to Rav Kester. According to Rabba, it's the same thing. He also, just hang on, he also doesn't have to pay because the husband died after she miscarried.
Can I just make a point?
Yeah.
The money's not ownerless while the husband's alive. So in my opinion, when that husband dies, that money is not ownerless because it was given to him prior to him dying. So that money, he can't take that money back.
Yeah, but
money can't be owned and then all of a sudden become ownerless. But not that, it could become ownerless, but not to him.
No, but the Gemara is using the following phrase, okay? So it says, look, at the end of the day, it does use the phrase hefker, which means as follows. I'll just explain it like this. Is that when you say it's ownerless, there's nobody to take it in his estate. There's nobody that's going to be the beneficiary. There's no halachic heirs. And since whatever's in that particular amount in his account at that time, does that get distributed to the wife, or does it? I would imagine so. But I'm sure we're talking about a case here where the damages, Kevin, for miscarriage are big. And therefore he's paying every month, because the Gemara uses the term that because it's hefker, because it's ownerless, Gavin, the one who has the money seizes it. He's got an ownerless estate. And therefore, since he seizes it because it's technically in his possession, the damager, that amount owing is ownerless. It's got no home. The amount owing is ownerless. So therefore, whoever has it has possession, meaning if he hasn't paid it over yet, maybe he owes like 100 grand and he's paid over 2 grand, and every month he's going to pay over a certain amount, like over 49 months, the rest of the balance. Then he's hit the gravy train because he doesn't have to pay. He's in possession of ownerless money. However, what happens with that money that's already been transferred to his estate? Does that go to the wife? Yes, I think so. It probably would, because it's out of his realm and she's got first acquisition to it. I'm just guessing.
But it definitely, in my opinion, can't go back to
that guy.
To that.
I agree.
I don't know what happens. I can't guarantee it goes to her, because we don't know, because he doesn't have any heirs. So we're not 100% sure. But it definitely doesn't go. That other guy has no right to it, because it's no longer ownerless. It was paid to the husband when he was still alive, when the money was ownerless. Whatever he paid over, even if it's just the $2,000 payment, that money was ownerless at the time. The balance of the payment would be ownerless, and it would obviously fall away.
I agree with you. Right. Listen, I don't know enough about it, but what you're saying to me is what I agree with. Anyway, let's just say how Rav Chisda, because Rabbi is saying, look, this is an argument that I've got with Rav Chisda, Rabbi is saying, is the same dispute as repeated by the Tanaim. So then the Gemara is saying, well, can it be that it's not a dispute? And according to Rav Chisda, it can be. So we just need to explain Rav Chisda that in fact it could work. Both of those contradictions could work within Rav Chisda's opinions. This is what it is. Sorry, guys, we only at 49b1. We haven't covered a lot, so I just want to cover a little bit.
Can I say something?
Sure.
Going back.
Sure.
It says something about if the woman was a Canaanite slave and she miscarried, then she gets the damages. Is it because after an emancipated Canaanite, is it because she has the status of a halakhic Jew?
So it depends what damages we're talking about. If it's damages, the only thing she's entitled to, okay, is she's entitled to damages for pain, and actual damages, if she's a halakhic Jew, is shared with her husband according to Rabbi Shimon ben Gamliel. It's shared with her husband according to Rava, because there was a value of what she was like pregnant and now she's miscarried. But if we're talking about actual physical damages to her body, not the loss of her good looks due to a robust pregnant state, what happens is, say she was really hurt in a visible part of the body where the husband's embarrassed now to be with a person that looks a little grotesque, he gets 2/3 of the damages, she gets 1/3. In a concealed part of her body, she gets 2/3 of that damages and he gets 1/3. She gets the full payment for the pain. In terms of damages for the offspring, he gets it all. If he dies while she's pregnant and miscarries and doesn't have a husband because she's a widow, she then gets it all according to Rabbah. According to Rav Chisda, there's no payment due by the damager. That's the bottom line of everything so far. Do you agree, Gavin? A few sentences. That's the bottom line of everything. All right. So let's just cover Rav Chisda and see what it's talking about, because the Gemara says, according to Rabbah, it's a Tanaic dispute. But according to Rav Chisda, shall we be also forced to say that it's a matter of Tanaic dispute? Or can we perhaps both explain both brises as compatible with Rav Chisda's opinion? And Kevin, that brisa is what happens to the money if she's a widow and then she miscarries? Does the money come to her from the damager, or is he exempt from paying? Okay? At the point where he dies before she miscarries. So the Gemara answers, look, there's no difficulty in reconciling both brisos with Rav Chisda's view, because we can explain that they're not dealing with the payment of the offspring themselves, because the brisos are very unspecific, but with payment for the appreciation that occurred in the woman through the offspring and that was lost through her miscarriage. So, guys, what it's explaining is the brisos we just learned didn't talk about offspring. It just talked about damages. So you can say that it's about the payment that the damager owes because she was pretty and beautiful in a robust pregnant state, and in a miscarriage state, she doesn't look as physically attractive. So if we use that as an example and we follow the opinion of the rabbis, we exempt the damager because the benefit of the beauty that she developed in a pregnant state goes entirely to the husband, okay? Because at the end of the day, when she doesn't look as pretty, the husband himself feels that he's lost his supermodel wife, you know? So he's the one that really suffers the loss. Women don't really, they want to look good, but he's the one that has to live with somebody that he doesn't feel is as beautiful. So since he dies, what's he got to complain about? So the damager doesn't have to pay, okay? But in the case where you're talking about the opinion of Rava, according to Rabbi Shimon ben Gamliel, remember we learned that, Rava turns around and says, look, they both share the money for her enhanced beauty. Why? Because, Kevin, picture this. She looks stunning. She's pregnant. She's robust. Husband's very attracted to her. She loses the baby. It causes contention in the marriage, right? So since it causes contention in the marriage, she's embarrassed. She wants to look her best for the husband. Her physical body is going through all the work. She's going through morning sickness. The husband's getting a good eye candy, but at the end of the day, she's going through the difficulty, and her body is reacting to the fetus, and her body is causing the benefit. So therefore, they split the benefit of the appreciation of her good looks now that she's pregnant. When she miscarries because of the damager, he has to pay half the money to the husband and half the money to the wife. Okay? And since that is the case, if the husband was alive at the time, okay, then half would go into the husband's estate. If he died afterwards, tough luck. She couldn't get her half, okay? And she would get her half for what is owed. That's if the husband is alive. If he died later, it's fine. But if he died while she was, what do you call it, in a pregnant state and then miscarried, but he died before, then basically she still should get her particular portion, because according to Rabbi Shimon ben Gamliel, she gets her share. It's not about offspring. So again, according to Rav Chisda, if you explain it according to the rabbis about her loss of appreciation due to her increased robustness for pregnancy, the rabbis say the money goes to the husband. So he doesn't have to pay the damage if the husband is dead. According to Rabbi Shimon ben Gamliel, with the appreciation, according to Rava's explanation of Rabbi Shimon ben Gamliel, what happens there? Husband and wife share the payment for her loss of attractive beauty because she and him both suffer as a result. Okay? So both opinions now can be explained according to Rav Chisda, depending if Rav Chisda is quoting the rabbis or Rabbi Shimon ben Gamliel. So what does the Gemara say to that? It objects. It says, if the brisa holds the damager liable, and that reflects the opinion of Rabbi Shimon ben Gamliel, and refers to the payment for the woman's appreciation through pregnancy, why does it deal specifically with the case where she was struck after the convert's death? Even if it occurred during his lifetime too, she receives one half of this payment. So the question is that, look, it doesn't matter. Why would there be a contradiction according to the opinion of Rabbi Shimon ben Gamliel? Because if the husband is alive, okay, she still gets half the money for the loss of appreciation, and he does. So what do you mean? What do you mean that the damage is exempt? How could he be exempt according to Rabbi Shimon ben Gamliel? He's never exempt from the wife's portion. Does that make sense? That's what the Gemara's objection is. So the answer is as follows, is that if she's struck during her husband's lifetime, she receives one half of the payment for the appreciation for her body image lost through the offspring. But if she's struck after his death, she receives the entire payment for this benefit. So the brisa actually means that the damage is liable to pay her this value in full, and therefore specifically refers to a case where he struck her after the husband's death, because upon his death, according to Rav Chisda, she is entitled to the share of the payment. Okay, we're going to find out why. So there's an alternative answer. If you prefer to say that according to Rav Chisda, both this brisa and that brisa reflect the opinion of Rabbi Shimon ben Gamliel, but they deal with different issues. Here in the brisa that holds the damage liable, we're dealing with the value of appreciation in the woman through the offspring. Okay? Whereas here in the brisa that exempts him, we are dealing with the value of the offspring itself. In other words, that Rav Chisda holds that at the time of the convert's death, his wife acquires the right to share the payment for the appreciation of her body, according to Rabbi Shimon ben Gamliel, through the offspring. But she's not entitled to the right of the payment of the offspring. That goes to the husband. So, in other words, if the damager strikes her after the convert's death and causes a miscarriage, he's liable to pay in full for the loss of appreciation because she can inherit that right. But she's not entitled to inherit any rights of things she wasn't entitled to start with. Have you falling asleep a sec?
Yeah.
So what I'm saying is this. What I'm saying, Gavin, is this. Is that, look, anything that she was entitled to half payment, according to Rabbi Shimon ben Gamliel, while she was alive, in terms of her body image payment. You get what I'm saying? She was entitled to half, the husband was. Upon his death, she can inherit that portion. But something she was never entitled to, like damages for the offspring, she doesn't get to inherit when he dies. It has to parallel.
Mm.
Does it make sense, Gav? All right, let me just.
Otherwise, she would have been entitled to it from the get-go. There wouldn't have been this dispute. There wouldn't have been this. She would have been entitled to damages for her offspring that she lost.
Yeah. So, in other words, exactly that. So, they say from the law stated here regarding the appreciation of a woman through the offspring, let us infer what the law is regarding the value of the offspring themselves. Since you concede that upon the convert's death, his wife acquires his share of the appreciation in her body through pregnancy, it should follow that she should also acquire his right of payment for the offspring themselves. And furthermore, from the law stated here, according to Rabbi Shimon ben Gamliel, let us infer whether the law is according to the rabbis. Since you concede that according to Rabban Shimon ben Gamliel, who ordinarily awards the husband half of the appreciation through pregnancy, the wife of the convert acquires her husband's share upon death, it follows that according to the rabbis who ordinarily award the husband the entire payment, she also acquires her share. On what basis does Rav Chisda distinguish between payment for the appreciation through the offspring and the payment for the offspring of themselves, and between the opinions of Rabbi Shimon ben Gamliel and the rabbis? All right. So, guys, I tell you what we're going to do. You all look like you're fading a little bit. Should we call it a day here and do the